Hi, I'm Karl Konrad and welcome to our weekly editions of Australian Immigration News, where we cover important law updates and analyse some of the political migration issues facing Australia. This program is produced by Australian Immigration Law Services here in Sydney, the business I founded 23 years ago. Let's start with the major law change this week regarding the 191 permanent resident visa. Those who watched my previous videos about the 191 visa will know the Hong Kong stream opened in March of this year and the regional stream is about to open this coming week on the 16th of November. The good news tonight is the government has acted compassionately to allow members of the family unit of future 191 main visa applicants to be given a special waiver of conditions 8503 and 8534. These are both no further stay provisions, with 8534 being imposed on student visas and 8503 on many temporary visas. The most common example would of course be the tourist visa. Now, the family members can be on any visa when applying for the 191 visa, but if these no further stay restrictions are imposed, then they are not able to be included if they are in Australia. Of course, these conditions do not apply to those who hold visas but are offshore. Now, if your family member is in Australia and one of those conditions are imposed on their visa, you can now apply to have them waived, so you can apply. This means that the waiver must be given by the minister after due consideration of the facts. To waiver these no further stay provisions, you must demonstrate that you have a genuine intention to apply for the subclass 191 visa. So here's a simplified version of all this. As an example, your wife comes to Australia on a tourist visa, but she has condition 8503 on it. You can now apply to have that condition waived, so she can be included in your 191 application and stay in Australia with you while your visa is being processed. How's that? Now for some of the political news in the world of immigration here. According to the Home Affairs Minister Claire O'Neill this week, the immigration system is broken and needs a major overhaul. Of course, that is big news for the Australian media here to hoover up, and it has been covered everywhere. The Financial Review called it a gutsy immigration review, and that headline must have achieved great statistics for their online platform, so they used the word gutsy again the second time 4 days later. How novel. However, it was strange this week there was not a word in the Australian newspaper on this gutsy effort by Claire O'Neill. Very interesting. Now, of course, that wouldn't have anything to do with these three negative articles about the Immigration Minister Andrew Giles recently, would it? It would seem after these articles it did not make the ministers very happy, so they were obviously left out of the loop for the review breaking stories. I'd better be careful about what I say, but not being in the loop means I can say what I feel like anyway. In recent articles, it seems the former Liberal government is to blame for everything regarding immigration failures, from allowing criminal gang leaders to infiltrate Australia to creating despair and uncertainty for new immigration hopefuls waiting for years for their visas to be processed. Let's hear from the Home Affairs Minister Claire O'Neill had to say this week on ABC National Radio.
But there is an issue here around the visa processing system, and that must sound, I'm sure, a bit bureaucratic and boring to people out there. But we've had, when we arrived in government, there were 1 million unprocessed visas sitting in that system. It was taking enormous amounts of time just to work through visa by visa. You'd be very surprised to see the level of, this is not an automated system, so there's a lot of human interaction where we're literally looking through and trawling through visas to see whether they meet the very complex eligibility criteria that the previous government had set out.
I think everyone is getting a little tired of the "we inherited 1 million visas" backlog when we took office. Let's face it, that backlog was triggered by Australia shutting its borders, and nobody was complaining when that was done. Australians like to feel secure and isolated on their own private island. And the Western Australians, well, they had a nice patch of desert to protect themselves from the rest of us. And Tasmanians were happy too with their natural water barrier. If any politician who would have called a media conference saying they were going to spend money and resources processing migration applications to bring people to Australia, that would have been sort of walking the political plank. Of course, there was no excuse to stop the processing of those who were already here and helping us during the pandemic, waiting for their 489, 887, 491 and 189 applications, just to name a few. That was a real error of judgment by the former government. However, Australians were very demanding to get their travel exemption exemption applications processed and equally demanding when they were refused permission to leave. And so they lodged them again and again and again. It was a tough time, and let's not forget that. Okay, we get it. Now we need migrants and more people, but that is now going to take time to get the juggernaut of the immigration department back up to full speed. And that takes money, a lot of money. So get a grip, ministers. The Labor government effectively cut $400 million from the immigration department's budget, which does not help. We cannot scream out, we are in a race to attract skilled migrants when we don't have a full tank of gas. Now the review body has been set, and Claire has set out very elegantly why we need it and who is going to be in charge of it. She outlined her view on ABC's Radio National this week.
And we heard at the Jobs Summit enormous consensus across unions, across business, across civil society that this system can do so much for our country, but it's not working at the moment for migrants or for the people who need them here to help us.
But the problem is these three highly esteemed individuals running this review are not experienced migration practitioners. They haven't been there to experience the grassroots level of the evolution of the skilled migration system. This claim, oh, it's broken and we need a review, is beginning to seem like a smokescreen of the current ongoing problems. And of course then we have to wait till May when they're finished, and then the next budget comes along. Nothing much will have changed. And the reason is it takes so much time to create new visa subclasses, to table the laws, discuss them in Parliament, and then to enact them. So we are probably talking about the end of next year before anything significant could actually happen. And what are we going to do in the meantime? Still whinge about the million visas we inherited. We are drastically falling behind in the global talent race, as the Financial Review let KPMG express their frustration. So we have made a few suggestions of our own, based upon our last 23 years of experience and the tens of thousands of applications we have looked after. You only need 6 experienced practitioners like myself to get around the table for a weekend to outline what we can do to speed up the current system and make it fairer for applicants. A prime example of a system in chaos is reflected in the story by the ABC this week about a family in Launceston who are staring at being deported after 13 years in Australia. And what was the root cause of the problem? Same for them and the famous Green family we spoke about before, being let down by their sponsoring employers and thus their own visa refused. Easy fix. For every visa applicant whose application was refused due to the sponsoring business nomination being unsuccessful, just lift the Section 48 bar so they can find a better employer and try again. It wasn't their fault that their visa was refused, so why penalise them? And speaking of Section 48, also allow applicants for the 189, 186 and 482 visas to be free to lodge despite previous refusals for other visas. We want the skilled workers to stay here right in Australia. Why force them offshore to apply? And while you're at it, let the BVE visa holders apply for the skilled visas too. So many people who wanted to apply for the 190, 491 and 494 visas but could not, simply because the system does not allow it if you hold a bridging visa E. Another simple fix. Also scrap the validity time limits on skill assessments and English results. The only people who benefit are the English Test Centre owners and the skill assessment bodies who love the repeat business. For faster processing of temporary visas, scrap the GTE Genuine Temporary Entrant requirement, the biggest time waster of public money that ever existed. It is not used fairly or equitably and is used as a tool of discrimination against poorer countries. There are so many ways they could make the system fairer and simpler just by fine-tuning the current visa subclasses. We don't need time wasted on any major overhauls. We just need action right now. However, it is my guess that they're not offering enough money to join the public service, and they are struggling to find staff like the rest of us. Well, that's enough for one night. Those who have stayed to watch the whole program, we thank you deeply as loyal channel supporters. Those who tuned out earlier, well, they don't know what they missed anyway. As always, take care out there, and I'll see you next time. So bye for now. And by the way, the readers' comments section, that'll be back next week.